also appropriate. And also reviewing this recently, we didn't have on the different body cam. I requested that different body cam. I requested that have all the discovery. So we don't have all this one more body cam. One more body video from a different date. Video from a different date that is related. This time the people said 5,000 without 10%. 5,000 without 10%. The defendant has. A defendant case in misdemeanor court continuing case in misdemeanor court 2024 to DV from 2024 to DV for son. He also has a case out on Plymouth. He also has a case out of same victim for domestic violence. In this case, it is an FA. This case, it is a right with a knife with the knife. Took it out while they were arguing. Took it out. Pulled it out. Brought it down. Pulled it out. Down towards her. Down towards her. And while he was in custody from 2 to 6, he made 135 calls. He made 135 against the conditions of his bond. Was against the conditions of his bond. We have great concerns for her safety. We have great concerns for her safety. New cases contacting her, the same victim, and we would be asking that this same victim. We would be asking that at 25. Without the 10%, without the 10%, Your Honor. Into custody, Your Honor.
Response.
Regarding the actual charge, regarding the actual charge, the discovery myself, I did review the evidence is solely the testimony of the complaining witness. There has not been any evidence of a knife. There has not been any evidence of a knife. My client does deny phone calls. Allegations. We have not received a violation report. We have not received a violation report with him. Discuss that with him. I was going to ask for an adjournment because we have not been able to speak about this case. I was going to ask for a week adjournment so we can go through the evidence and possibly go through the evidence. At that point, we can address Bondican at that. Address at that Bondican at that.
But he's indicating. He's indicating not made that calls.
He's saying it was not him making the call. He did not. It was not him making the call. He did not make any calls to the complaining witness.
And I believe they were from his PIN. To her number stated. And given that he already has multiple other cases, would still be contacting her on custody. He'd still be contacting her on custody.
I would ask. He is. Your phone was okay. He is. Your phone was. Let it give you the iPhone. It is my understanding that he is gainfully employed. He is a father. He can remain out on bond. With a tether.
Well, but I'm a bit concerned about these cases coming out while we were at the bench. So that it's clear. Prosecutors indicating to me calls are coming from the jail from up to the 6th. When he's released on that day. But he's arraigned on the 4th. He's arraigned on the 4th. It's clearly indicated to have no contact. So, and if it came from his pen, I mean, so I'll adjourn this to February 20th, 2025. I'll adjourn it out 1 a.m. I'll adjourn it out 1 week.
Would we be provided with the calls? Send the email to have those released today.
I'm going to set his bond at $25,000. Cash surety as the amount. What was his bond set at?
I believe it was the 25,000 with the 25,000 and then the other case he got anomalous. $100
So defendant's going to be remanded. He'll need to post that. At this point, defendant's phone privileges, given what the court has heard, are revoked. So that he'll go into the jail. He won't have phone privileges. This is the court's intention. You can get those. And then you can get those. Client. We get figure it out. Clients. We figure it out next week. At this point, defendant's remanded. Court does call the case People versus Brandon. I'll recall the matter. People versus Rashad Young.
Alex, and on behalf of the people.
Oh, there you are.
Alex, and on behalf
Okay,
of the people.
I didn't know where you were at. Okay, I didn't know where you were at. It's like
Ashley Moulton on behalf of
Yes, and Mr. Young, he was taken in custody. I'm not bringing him back up. I'm not bringing him back up. Only my understanding is the alleged victim wanted to address the court. So we could get. Your name?
Tandiana Yates.
Your name?
Tandiana Yates.
Ma'am, I'm gonna let you know. I'm gonna let you know. For the people in the prosecutor's office. For the people in the prosecutor's office. I wouldn't be calling your case back up. I'm just gonna let you know. You don't come into the court that way. You don't come into the court that way. Am I clear?
Yes.
Am I clear? What did you
Yes.
want to tell the court, man? What did
Okay,
you want
first
to
I
tell
want
the
to say I
court, man?
fully apologize for coming in here like that. Apologize for coming in here like that. I was unaware. I was unaware. I'm sorry. I just want you to know. With this whole case, I just want you to know. Instead of incarcerating somebody.
Go ahead.
Y'all need to try to help him. Y'all need to try to help him. The prosecutor. I don't know if the prosecutor let you guys know. Yes, but he hasn't. You can talk. I don't want to overtalk you. You can talk. I don't want to overtalk you.
But I'm just gonna let you know. But I'm just gonna let you know. I'm not that. I'm not to eat. You wanted to address something to.
Yes, because I feel like it was. Yes, because I feel like it was accurate.
I will listen to you. I'm not gonna tell you. I'm not gonna you sit here and try to give me a lecture
Oh no, I will never do that. But I just noticed inaccurate information that stated inaccurate on you guys' record, and I just fully disagree. Inaccurate information is stated on something that's very important. With the prosecutors, they should have called me. With the prosecutors, they should have called me instead of giving out inaccurate information. Because I would have just let you guys know. When I looked on that Zoom, inaccurate information stated. I don't know what you in this courtroom. I don't know. I just fully disagree with that. So I wanted to fully disagree with that. So I wanted to make that known.
Okay, let me just say this. Because you kind of blurted that out when you blurted that out busting and you had come busting. So
and my apologies.
So that you can understand. So that you can understand what you're saying. And what is being said. Because when you said that, everybody's obligation, his counsel, the prosecutor's counsel, and even in some respects the court, to double check what somebody is saying, if a decision was made based upon inaccurate information. Let me tell you that the prosecutor, as with her duty, checked what you were saying. I don't think, at least preliminarily, and they discussed his counsel, that what you're saying is correct. That what you're saying is correct. That it was at least with reference to what I was using. My decision on the remand. There will be a hearing that will be set next week. At that hearing, all of that will come out. But at least preliminarily, it does not look like the information was in any way inaccurate. Some of the information with reference to the dates.
All right, pause right here. This is where things get tense. She's claiming inaccurate information, which in court is a serious accusation. But notice how she's emotionally charged while the judge is focused on process, not feelings. This clash, it's about to decide everything.
My phone, someone, so we can call my phone because I no longer have that cell phone number. It's to my sibling. It's to my. You guys stated on.
If there are references to the case, we thought about that, ma'am. We thought about that. If there are references to the case, references to the case, references to other things that are. So I have not made a final decision. But at least preliminarily, what is being represented to the court appears to be true. And We will flush it out at a hearing. We will flush it out at a hearing because that's the way our system works. I have that. Preliminarily, I have that. Need to be done to enforce the orders of the court regarding the orders of the court regarding no contact. It seems that was violated. It seems that was violated. Due process right to a hearing next week. Right to a hearing next week.
But how is it violated when I have not physically? Just like when I came into the courtroom, just like when I came into the courtroom down, he made it aware that I couldn't be. He made it aware that I couldn't be around.
I will listen to you. I will listen to you.
That was just very accurate to me. That was just very accurate to me, and I just felt like the way that somebody should have. Somebody should have.
Y'all did what? Don't you turn your back on me. Turn your back on me because you are trying my patience. You are trying my patience.
This is textbook due process. The judge is saying, I'm not deciding guilt right now. A preliminary decision can be made to enforce court orders, but the real fight happens at the hearing. That's how the system protects both sides.
You are not listening. You are not listening. Say another word to me. Do not say another word to me. Mr. Allen, remove her. Mr. Allen, remove her. Remove her. You keep talking and there's going to be a problem. You keep talking and there's going to be a problem. There's going to be a problem. There's going to be a problem.
If I may, Your Honor, Lauren Brown, Deputy Chief. If I may, Your Honor, Lauren Brown, Deputy Chief. We did speak about that. She expects to have that today. That'll give plenty of time plus. That'll give plenty of time plus. Prepare for it. The one works for us. We'll be ready for it.
Here's the turning point. Instead of stepping back, she pushes forward. And in court, tone matters just as much as facts. Question for you. Should judges allow more leeway for emotional frustration, or is this exactly where firm boundaries are necessary?
This is available the 4th. Preliminary examination in person, March 4, 2025, 9 a.m. 2025, 9 a.m. Judge Perry. Continue.
May I?
Continue.
May I?
I'm sorry. Maybe not. Go ahead. I'm sorry.
Last week we addressed this defendant's phone privileges. After those were revoked, then continued a different number that we have, a different number that we have. Well, he called under her name as well. He called her 23 times. There were some under his own pin, and then some